Our law firm represents a lot of people who are charged with theft of large items, small items, money, bank issues, you name it. And, obviously our goal whenever you come to us is to try and win your case. And I did another video on how to get these types of charges dropped, and you should watch that video. This particular video that I'm about to do, I'm going to discuss the issue of how to win at trial. So, in other words, the Crown is not prepared to drop the charge, they're not offering a good deal that the client wants to take, and we feel it's a potentially winnable case, so we're heading off to trial. So the most important thing, theft, just like any other criminal charge, the Crown really has to prove several things, the elements of the offense. They have to prove that you're the one that did it, that you did the act, and that you had a guilty mind. That's called Latin term is mens rea, meaning you had guilty intention. So as a lawyer, I'm looking to see if there's a defense for any one of those issues on a theft trial. It really boils down to that. So very early on in the case, after you retain us, right away, our staff is going to order the disclosure. That is all of the witness statements against you, the police reports, the police notes, any surveillance, banking records, whatever the disclosure is. It could consist of 50 to 100 pages on a simple case, up to thousands of pages in a theft of a large-scale banking theft, you name it. Bookkeeper theft, accountant stealing from clients, you name it. So what do? We get that disclosure and I review it. And that process may take hours, it may take days, depending on the length of disclosure. But I'm looking for any defenses I can see there on those three basic elements. Can they prove identity? Can they prove the act? Can they prove that the person had a guilty mind? And once I analyze it, I take a hard look at it, and then I'm ready to meet with the client. So I set a meeting with the client, and that's our initial meeting. And if this matter has a trial, we're going to have so many meetings it's going to spin your head, it's particularly on a difficult case. But even on a minor case, there's so many meetings leading up to the trial. But this is the first meeting, and I review the disclosure with the client, and I point out any weaknesses in the Crown's case to them. I review all the facts in the disclosure, basically. And I formulate in my mind, what are the odds of winning this case? Is it unwinnable? Is it, looks like a good case to win? Or is it somewhere in between? Is it 50-50? And then I receive the client's verbal version of events. I take that down, and then, again, that's the first of many meetings. But the next step I do is I have the client review the disclosure in the office by themselves. That may take one day, it may take many days if it's complex disclosure, and write out their version of events. And these become our roadmap or our guide to defending the matter. Now, for example, let's take a minor theft charge, a shoplifting. So the client goes into a store and he's shopping around, puts a lot of things in his cart, and puts a minor item in his or her pocket, forgets about it. It just does it absentmindedly. It's an accident. There was no intent there. Those cases can often be won. I mean, I've run many of those types of trials over the years and won many of them. It's just a simple accident. It happens all the time. They get confronted in the parking lot and they go, "Oh my God, I forgot to pay for this," or "I forgot to pay something on the bottom of my cart." You put all the other items on the cart, but you wheeled out with the small item on the bottom of the cart, or small item that you absentmindedly put in your pocket. So that's one example on a minor theft charge. So identity is something we often focus on because some theft cases are circumstantial cases. There's no direct evidence of who the thief was. It's a circumstantial case, and it may be weak, or it may be 50-50. And we go to trial and challenge that the circumstances don't point exclusively to that person. They could point to other people. Just an example, at an office, you have a cleaning staff come in at night. There's a bunch of people in that office. There's only one cleaner, and the person says, I left my watch in the desk, and the cleaning staff was the only person who had access. Well, is that really true? They're the only person that had access, or other people could have stolen it? Can you really prove that they had exclusive access? Can you really prove the last time you saw your watch? So that's kind of just a circumstantial case, and those can be often very weak as well. There's also charter challenges where a person gave a statement. We can often get those thrown out if they, for example, they admitted it to a theft, but there's no other evidence against them. So these are the things that we're working on a theft case. I mean, they can be very complex. If the client needs to testify, you need to properly prepare. The lawyer, I'm going to prepare that client for hours to testify. Even on the most minor shoplifting case, we need to get their version of events straight in their mind. We need to tell their story in a compelling way that sounds credible and reliable. And then I need to do mock cross-examinations where I pretend that I'm the Crown and try and destroy them in the office and correct what they're saying in the sense of having them anticipate answers better and answer in a more compelling way so that they create a reasonable doubt. Now, like any criminal matter, a theft must be proven beyond reasonable doubt. The burden of proof is always on the Crown. And ultimately, the judge has to apply the WD test if the accused testifies in a theft trial. 3 steps of WD, Supreme Court of Canada test. If you believe the evidence of the accused, I didn't do the theft, I didn't intend to steal the good, you must acquit. Second step, okay, I don't believe the accused, but am I left in a reasonable doubt by the evidence? Am I sure? No, I mean, they probably did it. And in fact, I'm more certain than even probably, but I'm not sure. I'm still left with a reasonable doubt. You must acquit. Go on to the third level if they testify. Even if I totally disbelieve the accused, on the rest of the evidence, is there still a reasonable doubt? I've won cases on that with the many trials over the years. I don't want to say the number. On the third branch of WD, where the judge rejects the evidence of the accused completely, but the rest of the case is just not certain in the judge's mind, and judges will often say, yeah, I know you did it, or you probably did it, I'm just not, I have a reasonable doubt, even though I'm completely rejecting your evidence. So there's ways and means of winning theft matters. When I take a matter to trial, it's usually a case that we have a reasonable chance of winning. It's rare for me to say to a client, look, you have no chance of winning. Clients don't go to trial on that. They want me to negotiate the lightest deal. The occasional client will go to trial on when we have a low chance of winning, and sometimes we get lucky and win those cases if it's low odds. But I can tell the odds from the client's version and the police reports. I always recommend to go to clients to trial, when they have at least a reasonable shot at winning. It's up to them when it's less than that. I don't guide them that way, but I always recommend. And we often win those cases, that the burden's in your favor, theft charges can be won. And you know what? As lawyers, our job is to guide the client to the right decision. I mean, there's no use going to trial on a case you can't win. That case, you need to try and negotiate the best possible, most lenient sentence, and lawyers should go to trial in the cases that at least have a reasonable prospect to win. The client has advised us they didn't do it. There's a reasonable prospect to winning, and that's our job, to try and create reasonable doubt at court, show the improbabilities and inconsistencies, show they can't prove identity, show it's a poor circumstantial case, or show it was an accident in a shoplifting sense, or show the paperwork at the bank doesn't exclusively point to the bookkeeper or the accountant or the lawyer stealing money. Unfortunately, lawyers sometimes get charged with stealing money in this province, which is very upsetting to me, but fortunately, rarely. So that's how to win. That's a short summary of how to win a theft matter, whether it's a minor matter or medium or even a complex theft. It's the same principles that apply to any theft trial. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.